pleased to be joined by members of our OPIA and OLA staff. And with us here this morning, we have Kim Hudson, John Mearshite, Kathy Schievelbein, Gunther Moscat, and Seth Lichny is also here with us from OPR. And we also have Marilee Hansen from OLC. Please stay with us. You will be hearing some new information as well. Here's a list of the topics I'll be covering today. Why CEQA applies to DTSC, a brief explanation. How CEQA is implemented within DTSC, the roles and responsibilities of OPIA and program staff, DTSC preliminary environmental review process, the steps to the environmental review process in DTSC, the notice of exemption process, steps to completing that process, steps to completing the initial study process, and OPIA technical assistance and resources of information and staff. Okay, first let's start with why CEQA applies to DTSC. As you can see from the slide, CEQA applies to DTSC because it is a public agency that carries out or approves projects that may have a significant effect on the environment or some level of effect on the environment. The typical types of projects that DTSC encounters may include those you see listed on the screen and possibly others. Okay, next I'll talk about the roles and responsibilities of DTSC core and shared services programs in carrying out the requirements of CEQA and the guidelines. And let's begin with OPIA. OPIA was established as a result of recommendations from a 1990s legislative task force report that concluded a centralized DTSC headquarters office was needed to ensure consistent and transparent implementation of the requirements of CEQA and the CEQA guidelines. Our office is located within the Office of Legal Affairs and is comprised of associate to senior level environmental planners. Our responsibilities include developing policies, procedures, and guidance related to CEQA implementation within DTSC that you can access on OPIA's SharePoint site, providing CEQA technical assistance and guidance to program staff and management by telephone, in-person consultation, or through written material, reviewing and approving all CEQA documents before public notice is issued, and reviewing final CEQA documents before filing them with the Governor's Office of Planning and Research State Clearinghouse. Some of the typical documents that we review are notices of exemption, initial studies, negative declarations, environmental impact reports, and National Environmental Policy Act, or NEPA documents. We also provide assistance to the Office of Communications on the CEQA process descriptions and project fact sheets and public notices. We serve as the point of contact with local, state, and federal agencies, local planning departments, the Native American Heritage Commission, trustee agencies such as the Department of Fish and Wildlife, and others. We also serve as DTSC's point of contact with the Governor's Office of Planning and Research on CEQA technical matters. We sponsor and conduct CEQA training. Some of you may have attended the recent Air District training. We're currently in the process of developing a session with the Sacramento Metropolitan Air Quality Management District, along with other CEQA-related topics. We're also planning a session on DTSC's roles and responsibilities as a responsible agency under CEQA and public noticing requirements under CEQA. We process the California Department of Fish and Wildlife Notice of Determination filing fees, and we track environmental documents reviewed or prepared by program staff through EnviroStore. Let's see.
And we do have a question.
Okay, we have a question.
Do we need to do CEQA every time we receive a document? RI, FS, RAP, RAP.
Okay, well that's an excellent question. It will depend on the environmental consequences of carrying out that particular type of activity. The best thing you can do in that circumstance, if you're not sure, you're kind of confused, on that sliding scale from no effect to some potential effects. What you can do is submit an EnviroStore request for maybe a 2 or 3 hour consultation from our office, and you can send that request to Kathy Schiebelbein, our chief of the Office of Planning and Environmental Analysis, and she'll assign a planner to work with you, and we'll review whatever document you have and give you some advice as to what direction would be appropriate under the circumstances. Okay, now I'd like to show you some of our recent accomplishments. Here's a snapshot of OPIA's accomplishments for the 2012-2013 fiscal year. As you can see, we've been pretty busy, and environmental impact reports are keeping us particularly busy. Among the 13 EIRs reflected in that total are the ASCON landfill, Santa Susana Field Lab, Clean Harbors, Exide Battery, Clean Tech, and Domenico Cordune sites. And before we move on to program's role, I'd like to ask if anyone has a question. No?
Not
okay.
At this time.
All right. Now I'll talk about program staff's role in the DTSC CEQA implementation process. Program staff is tied into the CEQA process through discretionary approvals, such as permit determinations, approval of cleanup and remediation plans, and proposed regulations that have the potential to create a physical impact on the environment. DTSC core programs are responsible for conducting the CEQA-related activities that you see on the screen, consulting with our office to discuss a CEQA compliance strategy, resource needs, and a schedule for CEQA document preparation. In other words, the project manager works with the OPIA planner in arriving at a CEQA approach for the project that fits the circumstances and a realistic time frame for completing the CEQA process. Contacting the Office of Communications. The project manager initiates contact with the Office of Communications to get started on the community profile, public notices, and other public participation or involvement requirements. Preparing or overseeing the development of draft CEQA environmental assessment documents for projects where DTSC is the lead agency, including notices of exemptions, initial studies, negative declarations, and environmental impact reports. Program staff also reviews and comments on CEQA documents for projects where DTSC is a responsible agency, as in the case of a redevelopment plan for a contaminated site, a school site project, or a conditional use permit. Meets with affected agencies to obtain information needed for CEQA documents, for example, the Department of Fish and Wildlife, local air district, and others. Conducts public hearings, prepares and submits CEQA documents to OPIA for review. Program staff also approves, certifies, and submits the final CEQA document, usually a notice of determination or a notice of exemption, to our office for filing with the state clearinghouse. In addition to these activities, program staff also reviews comments received on draft CEQA documents during the public and agency review period. When CEQA-related comments are received, the project manager consults with our office when drafting comment responses. So, no questions so far. Okay. Now I'll move on to the Office of Legal Counsel's role in the process. As a public agency, DTSC must comply with the legal requirements of CEQA, just as it must comply with those of the Health and Safety Code. OLC attorneys are tied into the CEQA process by providing CEQA legal advice and consultation on a project-specific basis, on projects or policies of statewide importance, such as the Safer Consumer Products and CEQA greenhouse gas emission evaluations, attending CEQA compliance strategy meetings at OPIA's request when legal issues are expected, as in the case of highly sensitive cultural sites, issues with another local, public, or trustee agency, or other CEQA technical legal issues, and representing DTSC in CEQA-related court challenges on projects such as Industrial Oil Services Company and the Topak compressor site.
No questions, that's right.
Okay. Now we'll move on to the Office of Communications role in the process. The Office of Communications has a role in the CEQA process because DTSC is required to comply with the public review and public participation provisions of CEQA before carrying out or approving projects. The Office of Communications conducts the CEQA activities you see on the slide. OC provides consultation to program staff and management regarding the public interest in the project, contacts OPIA for the text of CEQA compliance descriptions for project fact sheets and public notices to ensure their accuracy. OC develops and plans public participation activities such as community surveys, and sets up the public repositories for the CEQA and project documents for the public notice period.
No comments.
We're going to pause for a moment while we check to see if we have any further questions.
No, not on my side.
Okay, no questions at this time. Next, I'll give you an overview of the steps in the preliminary environmental review process that DTSC undertakes to comply with CEQA requirements that Seth discussed from a general statewide perspective earlier. The preliminary environmental review starts with DTSC determining if an activity or project is subject to CEQA. As a project manager, you will do this review in consultation with OPIA. To be subject to CEQA, the activity must involve the exercise of discretionary powers by DTSC. DTSC discretionary powers authorized under the Health and Safety Code include, but aren't limited to, permit determinations, remediation and cleanup plan approvals, and regulation package approvals. The activity must be a project, meaning a project that has the potential to result in either a direct physical change in the environment or a reasonably foreseeable indirect physical change in the environment. For example, removing contaminated soil by excavation, permitting a facility, a regulatory proposal that changes the procedure or process, and so forth. And the project is an activity directly undertaken by DTSC, as in the case of an orphan site cleanup, or an activity undertaken by a person which is supported in whole or in part through contracts, grants, subsidies, loans, or other forms of assistance from DTSC, or an activity that involves the issuance to a person of a lease, permit, license, certificate, or other entitlements for use by DTSC. For example, a facility permit, variance, or a cleanup.
If I can jump in, we do have a follow-up question regarding work plans. And the question is, are we expected to do a CEQA analysis every time we get a work plan to install wells or other drilling operations?
To install wells, that's an activity that could definitely have some environmental consequences. Drilling in and of itself may seem like a benign activity if you know that this appears to be some abandoned area that's devoid of any obvious resources. But consider the fact that in California we have many instances where cultural resources may be buried below the surface, and also habitats can sometimes be in places that appear to be very barren. So the answer to that question, if you have a work plan, yes, you need a CEQA evaluation on that work plan. And again, please contact our office initially for consultation. Okay. All right. Going to the preliminary environmental review process. If the activities constitute a project, then DTSC determines whether the activity is otherwise exempt from CEQA. There are various types of exemptions under CEQA that include, and this will be a little bit of review for us all, as Seth discussed some of these, statutory, for example, certain types of infill development projects, transportation projects, emergency projects, and many others. However, a DTSC doesn't currently have a type of statutory exemption. Categorical, small cleanups of $1 million or less, and some limited regulations for the protection of the environment. A good example is the mercury thermostat collection rules, which were mainly just a procedural type of regulation. General rule where, with certainty, there is no possibility of a significant environmental effect, and rejected or disapproved projects, no project equals no need for CEQA. If the project is exempt, then DTSC can initiate the notice of exemption process that I'll describe in a little more detail shortly. If the project is not exempt, then DTSC is required to conduct an initial study. And I'll also tell you about the initial study process a little later. But first, I think we have a question.
We have a question about cleanup work plans. There is a CEQA exemption for cleanups of $1 million or less, so why should there be a CEQA review of such cleanup projects?
Well, that's a good question. And the exemption on its surface may appear to be very encompassing and very, meant to cover a lot of things without any review, but that's not the case. If you'll go to our SharePoint site and take a look at the requirements for determining whether an exemption is appropriate for a project, there are certain factors that need to be taken into consideration. Even though you may feel that the project fits an exemption, and perhaps it does, you first need to rule out potential effects such as unusual circumstances, effects to biological resources, cultural resources. Wherever you have an excavation in California, unless you're digging into soils that are non-native, there could be a potential for buried cultural resources, and any other number of factors.
We have another excavation question. If after an excavation the area is backfilled with clean soil and restored, does that constitute a physical change?
Yes, that would constitute a physical change.
Okay, and one more. The question is, my understanding is that CEQA does not apply to sampling, soil, groundwater, or installation of wells for investigation. We haven't done that in the cleanup program.
Well, this goes back to a question that someone asked a bit earlier. And the question you should be asking yourself when you have such a project is, does the activity involve altering the environment, affecting the environment in some fashion? If you're just going out with, a cooler with a sampling kit and some test tubes, and you're just going to be scooping up some water and putting it in that container and leaving the site, obviously, you don't have potential for a physical impact there. But where you have invasive activities like drilling, crunching up soil in some fashion, maybe you only plan to take out a foot in one little spot, and one little foot in one spot becomes 5 feet below the surface in a hole that's 6 feet wide. That's invasive. So you need to think about the sliding scale from zero effect to a potential effect. And if you have some kind of invasive activity, then give us a call.
This is Kathy Schiebenbein, and Laura, that was really well stated. I would also add, if what we are doing involves some sort of authorization on our part, some sort of approval, then you would need, and possibly have some direct impact to the environment, then you would need to contact our office, and we can do it. We can take a look at it and have a discussion with you as to what really is going on out there. Can everyone hear my response? If you can't, just let me know. Thank you.
Okay. One more question. Permitting was told that there would be no more notice of exemptions for permit renewals, and OPEA policy document will be forthcoming. Do you know when this policy will be coming?
I'm going to let Kathy and Mary Lee handle that one.
I'm working with Kathy and Gunther on that, and they will probably be issuing the policy per se, but I'll be giving my findings to them that they can base their policy on within the next few weeks. And basically, I can give you an overview of the approach that the conclusions I've come to based on my research. My consultation with OPR as well as legal research and so forth is that when you have a renewal, in general, the existing facility exemption is not going to apply, particularly when we have, or some agency, prepared a negative declaration or an EIR for the previous approval of the facility. So what we will probably need to do when we have renewals is it's going to be very, very important to have a description of what has already been permitted for that facility. What is the current facility permitted to do? Then it's going to be very important to compare that to what are they asking to do in their permit renewal request. And the key factors that DTSC is going to need to evaluate for CEQA purposes are those new activities, the new activities that the facility is seeking to do, as well as we're going to need to look at the changed circumstances in the neighborhood around the facility, and also changed circumstances in terms of what are the new regulations that exist now compared to 10 years ago when this facility was permitted. For example, the greenhouse gas evaluations were not required 10 years ago. They will now have to be conducted. So the bottom line is we're going to need to look at the changes that are going to result as a result of if we were to approve the facility's request for a new permit. Oh, and I'll just follow up and say that it's going to take some sort of environmental analysis in order to do that. An initial study naturally is the logical place to look, but we don't necessarily have to do a full-blown initial study, capital I, capital S, with all of the procedural requirements that go along with an initial study. We probably will, in many instances, be able to do something that we might call an environmental assessment, or it might have another name. But the bottom line is we're going to need to look at those same categories of environmental media and impacts in that analytical document as we look at those differences between the new permit request and the old permit, and also as that permit was modified over time.
And it looks like I've missed a couple of questions along the way. My apologies. Getting back to an earlier question, this is a follow-up. If you do a CEQA analysis on the RI, do you need to do another one on the feasibility stage, the RAP stage, et cetera?
Yeah, where you have, the RI is one piece of the puzzle here, and as you move along from the investigation phase to the implementation phase, yeah, those would be two distinct CEQA analyses.
Okay. Another question is, my understanding about the role of public participation in the Office of Communication is that the project manager deals with CEQA, not the PPS.
Well, the PPS has to, prepare all of the public notice documents. And that's why, as I pointed out earlier, when the public notice is prepared, as the project manager needs to make sure that that public notice is coordinated with our office with regard to what it says about the CEQA process. The Office of Communications is their role is not to assess what type of CEQA description should be included in the public notice. That's really between our office and the project manager, because we're working together on the CEQA process for the project. So we should be feeding that information to the public participation specialist. They shouldn't have to figure that out on their own. We should help them with that language. We should work together to supply the correct information.
Okay.
Also, I would just like, this is Kathy again, I would like to add on to what Laura just said, that we obviously need to work together. So we work closely with the Office of Communication. We take a look at fact sheets that are going out to make sure that the information being conveyed to the public respecting the CEQA component part is accurate. So you really need to think of these two offices as the essential component parts before you go out for your public notice. So I just wanted to chime in on that. And plus, we are going to be working with the Office of Communication on a kind of a training / seminar type of scenario, so that we can kind of link our processes a little more closely and provide you better support in the process. So I just wanted to add that on.
So we do have quite a few questions that are backing up. The next one is regarding impacts from investigations. We thought the threshold is significant.
Well, the threshold is really, is there a potential for an environmental effect on some level? Doesn't have to be significant. You need to consider whether or not the project causes an adverse effect. The significance level triggers an EIR or a mitigated negative declaration. So you don't have to just only consider effects that are significant, but you have to consider effects on that sliding scale, as I said before, from 0 to some level of effect.
Okay.
This is Gunther speaking. I think it might be helpful to look at it, as Seth pointed out earlier. Once you determine you have a project that has a physical effect on the environment, then you go through the process of determining, whether that effect is exempt, otherwise exempt, or leads to another environmental conclusion. And I think that there are other agencies like Health Services that conducts this type of assessment. They're drinking water well program at the PEA phase. So it's not unusual. So just use caution, I guess, is what we say.
Oh, and for those who may not be familiar with the terminology, a preliminary endangerment assessment is a PEA. We may have some viewers that are not within one of our cleanup or permitting programs. So just wanted to mention that for your benefit.
Okay, one other question. Laura, could you explain again the special circumstances in regards to permits that have no changes in the NOE?
Unusual circumstances. CEQA exemptions are not appropriate where the project may have an unusual circumstance, and the unusual circumstance is not defined in any particular way in CEQA. It's on a case-by-case basis, and so it just depends on the site conditions. For example, if you have a project that is within a habitat area for kit fox, let's say, and the project would have the effect of reducing the habitat area for the kit fox, that could be considered an unusual circumstance, for example, or it could be other things. Marilee has a comment.
I could add a little bit to that, too. We may think that a facility is the exact same facility, but we need to do an analysis of that. We're going to need to look at what did the previous permit authorize, and what is the permit What is the new permit renewal asking for? And we need to document how we come to our conclusions. It's not enough to just say, oh, it's the same facility, we're going to do an NOE. If we did a negative declaration or an EIR or some other agency did one before, we still need to analyze, is this really the exact same facility that got permitted back then? And then we also need to look at, have other circumstances changed? Maybe it's the exact same set of waste streams and volumes and everything else, but maybe the neighborhood has changed. Maybe the laws have changed. Maybe the regulations have changed. We need to look at all of that, document it, and then figure out where we go from there. If it's a situation where absolutely nothing has changed, we could do something like a memo to the file, documentation of our conclusion that nothing has changed. But it doesn't necessarily mean that we do an NOE, because NOEs are generally not appropriate where there has been previous CEQA review, unless you're doing something like a Class 1 permit modification where you're changing the name of the owner on the facility or something like that. That might still be appropriate for an NOE or just a general rule exception. But when we have permit renewals for existing facilities, we are not going to be able to just issue NOEs. In order for us to withstand legal challenges, we are going to need to have evidence in the record for how we came to our conclusions. So even if we wanted to do an NOE, we're still going to have to do some analysis in order to support that NOE. However, it's important to remember that if there was a negative DEC or an EIR in general, we are not going to do NOEs for permit renewals.
This is Kathy, and I just want to underscore the importance of substantiating the reasons why. We have to have in the record, we have to know, we have to be able to demonstrate those reasons that support that decision, whatever decision we make, but in particular, notices of exemption.
And we do have a comment that people need to speak up a little bit.
Thank you.
Another question is, do we need to prepare an initial study before filing a notice of exemption?
No. No, but I don't really fully understand your question. So I don't know the basis of that. So rather than take a lot of time here to try and figure that one out, please contact us and let us know. Maybe give us a little bit more information, because on the surface, no.
Okay. And then more questions are coming in. And the next one is, renewal applications for hazardous waste facilities with de minimis or no changes do not appear to have a physical change. So they are exempt in accordance with the, quote, project may cause either a direct physical change in the environment or a reasonably foreseeable indirect physical change in the environment, end quotes, and then correct or yes.
Again, we're spending a lot of time on this question. I think we've answered the question. It is on a case-by-case basis. You need to consult with us at the earliest possible stage, take some time, discuss with us the specifics of the proposed project, of what's going on in the permit, and then we will have a discussion with you about the appropriate path.
And then a quick comment. One of the changes for a permit renewal is that the facility is allowed to operate for another 10 years. So even the impacts of continuing the existing operations would need to be evaluated.
Correct.
Another comment is, since this will be a new OPEA, will OPEA offer a training on how we would do these environmental analyses? We will need guidance on training and training on how this will be implemented.
I'm not sure, again, what you mean by that question, because we're not a new Office of Planning and Environmental Analysis. We've been around for a long time. Our acronym has changed slightly, but we are the same. So I would need clarification on that question. And I think we need to move on so that, because we have a time limit on here. But please submit a more detailed question, and we will be happy to respond to you. Thank you.
Okay. Anything else, John?
Well, we do have quite a few more questions. A comment to Kathy is an earlier comment you made was, this is incorrect. The information given to PPS is done by permitting. We prepare the language and information that PPS puts into documents, not the other way around.
Yes, and I agree with that, and so I apologize if my message conveyed somehow confused that fact. We work closely with the Office of Communication, formerly Public Participation, to make sure that the information that goes out in things like fact sheets that relate to the CEQA component part are accurate.
Okay, and I'm going to need to skip over some comments. I think people are emailing each other, texting each other on this. Okay. Regarding permit renewals, if we conduct an environmental analysis and find there are no changes or significant impacts, why couldn't we include that in an NOE?
This is now the third or the fourth time that we're sort of dancing around the same subject. When there is a permit renewal request, which is really a discretionary decision to approve a new permit that will last probably 10 years at least, we're going to need to look at what sort of environmental documentation was done the last time around. Was there a negative deck? Was there an EIR? What did it find? What was the project that it reviewed? And what is the project that we are looking at now? If there was a negative deck or an EIR previously prepared, we will not be preparing NOEs. We will be deciding whether we need to prepare anything or whether we need to prepare a supplement to that old EIR or negative deck, a subsequent or an addendum, or perhaps a memo to the file. But we will not be preparing an NOE if there was a negative deck or an EIR prepared previously. Additionally, we're going to need to document in our files our analysis and why we came to the conclusions we came to. And in the long run, this will result in the permits getting out faster than they might otherwise, because hopefully we can come up with a streamlined process for doing this. But an NOE is just not going to be appropriate for a hazardous waste facility, you know, with a few exceptions like I talked about, maybe for Class 1 modifications, but not when we're issuing a permit for another 10 years for a hazardous waste facility.
Okay, I think
another quick question on a different issue, a different topic. Are there databases available to project managers on biological and cultural resources?
there is a database on biological resources that's furnished by the Department of Fish and Wildlife, California that is. Our staff is trained on conducting the database searches. If you need one of those, you can submit an EnviroStar request to our office, and Kathy will assign a planner to work with you to get that information. The Native American Heritage Commission has a database that they call the Sacred Lands file. Likewise, if you need that information, you can also submit an EnviroStar request to Kathy Schievelbein and get a planner assigned to you to work with you on a cultural resources evaluation. Due to the volume of questions,
one more question, and then we can move on. Somebody brought up the question about, will there be training on the OPEA policy regarding issuance of NOEs after a previous initial study or other type of document has been issued, and I think that's something we can consider.
Yeah, now, as we mentioned earlier, Marilee did, we sought a legal opinion on the issue of what is the appropriate CEQA analysis for the issuance of a permit. And so we're expecting that in the next few weeks. Once we receive that, we're going to develop an informational bulletin, and we'll also develop training, likely in the form of a webinar setting as we're experiencing today. That is correct.
Okay.
All right,
Let's
we're
move on.
running shy on time here, so I'll continue with my presentation. And if we run out of time today, if you'd be so kind to email your questions to me, we will follow up and share those answers on the SharePoint site. Okay, now I'll explain the basic steps of the DTSC Notice of Exemption process. After the project manager consults with OPIA and confirms that a notice of exemption is appropriate for the project manager prepares the draft notice of exemption using the form on our SharePoint site. Next, the project manager sends the draft notice of exemption to our office using the EnviroStor request to Kathy Schievelbein for OPIA review. The submittal process is described in CEQA Informational Bulletin number 8. That's also found on our SharePoint site. Our review length is a minimum of 15 working days, and during this time, our staff checks the NOE for consistency with CEQA, the guidelines, DTSC policies and procedures and guidance, verifies the analysis and findings. We will also review your DTSC decision document, be it a RAP, RAW, permit, etc., at the same time and compare the project description with what's described in the exemption draft. OPIA may also consult with OLC, affected agencies, and will decide if the public notice date can be met. The project manager will then coordinate the public notice and fact sheet content with our office and the assigned public participation specialist. The project manager also sets up the public review and comment phase for the project. And during the public comment phase, the draft NOE is marked with a draft watermark and made available for public inspection in the public repository and in EnviroStor. After the public notice ends, the project manager reviews the comments received and revisits the analysis to make sure it hasn't changed. And please note that OPIA's review of the comments and responses is required. The branch chief then approves the project and signs the final NOE. Upon project approval, the signed notice of exemption is returned to OPIA using the EnviroStor request to file the document with the state clearinghouse. Filing of the NOE with the state clearinghouse starts the 35-day legal challenge period under CEQA. It's very important that you return the final signed NOE to our office as soon as the project is approved to start the 35-day legal challenge period on DTSC's project approval. Because if the NOE is not filed, the CEQA challenge period extends to 180 days from the date of project approval. Our office notifies you when the NOE has been filed by electronic and hard copy. Next, I'll give you an overview of DTSC's initial study process. And first, let's start with the definition. An initial study is a preliminary analysis prepared by the lead agency to determine whether an environmental impact report, EIR, or a negative declaration, NEGDEC, must be prepared, or to identify the significant environmental effects to be analyzed in an EIR. In other words, the initial study can be used to reveal which project effects are expected to be significant and require further study for alternatives and mitigation measures. The scope of an initial study considers all phases of project planning, implementation, operation, and cumulative effects. Take, for example, a redevelopment project for an apartment complex, from ground leveling to people moving into the apartment complex, and the effects on transportation for the local area. Under CEQA, the whole of an action must be considered. The initial study conclusions must be supported by substantial evidence in the record, and that is no speculation, just the facts supported by information, And substantial evidence includes studies, reports, and other verifiable information. The initial study must be prepared before the public agency can carry out or approve the project, and the CEQA process must be completed before project approval. The initial study must be prepared early in the project planning stages so that a complete analysis of potential impacts can be considered before DTSC carries out or approves the project. And next I'll tell you how the initial study project process works within DTSC in cases where a negative declaration or mitigated negative declaration is proposed for a project.
Laura,
we have a question on an earlier issue about notice of exemptions, and the question relates to slide 19, and it is, what if the NOE is filed between the first 35 days and 180 days?
Between the first 35 days, I mean, oh, like it's been filed late?
Yes.
Oh, in other words. Well, you know, again, I'm not aware of CEQA challenges that have been brought up on that basis. I guess they potentially could be. Marilee, do you have a comment?
That would take a little bit of research on our part. I don't have an answer off the top of my head.
It's the question, if the NOE is not filed.
If it's filed late.
Late.
Within the 180 days, after the first 5 days, but within the 180 days.
Well, there is no 5-day thing. That only applies to the other CEQA documents. In the way that the process works under an NOE scenario is that you file it shortly after project approval, and the trigger is 35 days. But if you're dragging your feet, and also it's not only upon approval but also upon discovery. So if the department doesn't file and it lingers around for a bit, and then decides, 30 days into the process, someone finds out that we didn't file, the trigger is the 180, because the statute or the guidelines specifically state 35 if it's filed, 180 if it's not. And so that would be my interpretation of it. And I think Marilee is correct that she will take a look at that.
Okay. All right. Yes, I was saying the initial study must be prepared early in the project planning stages so that a complete analysis of potential impacts can be considered before DTSC carries out or approves the project. And let's see, getting back to where I was, I should put my thumb on the page. I apologize. So guidance on the preparation of an initial study to scope an EIR is going to be saved for a future training session. However, you can find some practical guidance on our OPIA SharePoint site in informational bulletin number 4 that talks about the depth of analysis required in initial studies. And the initial study process starts with the project manager contacting OPIA for preliminary consultation to discuss the project scope and activities that may affect the interests of any responsible or trustee agencies. For example, if the project involves excavation, the local air district, Native American Heritage Commission, Regional Department of Fish and Wildlife, state and federal if necessary, local planning agency, and so forth may need to be contacted. The project manager gathers data and information for the project and current physical conditions or environmental baseline setting in order to evaluate the project against this setting. And the baseline setting is the current condition of the project site before the project takes place, or the conditions existing at the time the project analysis commences. The project manager also contacts affected and responsible and trustee agencies for input on how the project affects their aspect of regulatory interest, for example, a local air district, water district, and so forth. And our staff is available to assist you with meetings with other agencies upon request. The project manager prepares the draft initial study using the initial study workbook and informational bulletin number 4, and both of these documents are available on our SharePoint site. Concurrent with the draft initial study preparation, the project manager coordinates with the public participation specialist the project schedule, public notices, fact sheets, and community involvement activities. The project manager also shares the draft public notice and fact sheet with our office to ensure the proper CEQA process is described in each notice. The process, as I mentioned, is explained in our initial study workbook. Once completed, the project manager sends the draft initial study and draft negative declaration or mitigated negative declaration, draft CEQA package that is, to the branch chief for review. The branch chief reviews the draft CEQA package and returns the package to the project manager, noting any changes that are needed. And when approved by the branch chief, the project manager forwards the draft CEQA package to OPIA for review by submitting an EnviroStore request to Kathy Schievelbein in accordance with CEQA Informational Bulletin number 7. Our staff reviews the draft CEQA package for compliance with CEQA, the CEQA guidelines, and DTSC guidance. Our staff will also verify the analysis and findings with the CEQA package and whether or not the public notice schedule is workable, and notify the project manager that the CEQA package is either approved for the public notice phase of the process or that revisions are needed. We request that at least 15 days be allowed for OPIA's review. Sometimes revisions to the initial study or additional follow-up activities with responsible or trustee agencies may be needed. Because of the possible need for follow-up, please allow extra time in the project schedule for revisions and reviews.
So there was a question about branch chief to review.
That's
What's
correct.
the question?
That's the entire question, branch chief to review.
Well, this is Kathy. We've gotten away, we think, we don't know, we're speculating, in the technical program areas from the chain of command being brought into your part of the development of the environmental analysis. We're hoping that that is still in place, that the first line supervisor and or the branch chief level does review what ultimately comes to our office. It is existing procedure, and it has been in place for many years. I think it predates my coming to this program.
Okay. All right, I'll continue on then. After the CEQA package is approved by OPIA, the project manager compiles the CEQA package for submittal to the State Clearinghouse to start the CEQA public notice phase of the process. The CEQA package includes the initial study signed by the branch chief, the draft negative declaration or mitigated negative declaration unsigned, the notice of completion and environmental document transmittal form, and a copy of the Department of Fish and Wildlife no effect determination. If the Department of Fish and Wildlife agrees there will be no effects on biological resources. The forms you'll need are located on the OPIA SharePoint site. And as mentioned, information on this process can be found in the DTSC Initial Study Workbook that's on our website, our SharePoint site. You can also give our staff a call if you need help in putting together your package for the public notice or have any questions along the way. The length of the public review and comment period is the same for a negative declaration or a mitigated negative declaration, 30 days. The CEQA public notice process mirrors the review for the DTSC decision document, for example, raft raw permit. And that is the public notice runs concurrent with the project decision document. Public comments are received and a response to comments is prepared. project manager coordinates the scheduling for the public notice with the public participation specialist. At the same time, CEQA has certain requirements for public noticing. And as the slide points out, CEQA packages must be made available for public and agency review in at least one of the ways you see listed. In addition, CEQA requires that the county clerk be notified for each county in which the project is located. The notice is filed with the state clearinghouse, and DTSC posts the CEQA document on its public website. Now I'll turn to the initial study public notice requirements. The contents of a public notice includes the items you see listed on the screen, a brief description of the project and its location, the start and end dates of the review period, the date, time, and location of any scheduled public hearings, which are encouraged but not mandatory, the address where copies of documents can be viewed, usually the lead agency office and the county library system. This notice must indicate if the site is on the Cal EPA Cortese list of hazardous substances sites. The Cortese list is available on the Cal EPA website. You'll need to check all 4 lists within that site. If you need help locating the Cortese list and going through the sites, just give one of our planners a call and we can walk you through that. Be sure to involve the OPIA planner in drafting the CEQA process description for both the public notice and fact sheet. Accurate notice can help prevent the need to renotice a project. If an extension to the public notice becomes necessary, also be sure to notify your OPIA planner. Okay, now I'll move on to the response to comments phase and final phases of the initial study process. After the comment period has closed, the project manager reviews the comments received and revisits the initial study analysis to ensure that circumstances haven't changed the conclusions. The project manager sends the CEQA-related comments and responses to OPIA for final approval. And prior to approving the project manager is required to take into consideration the findings contained in the draft CEQA document and comments received during the comment period. When all comments have been addressed, the branch chief approves and certifies the final negative declaration or mitigated negative declaration and forwards the notice of determination package to OPIA to complete the notice of determination filing with the Office of Planning and Research State Clearinghouse. At this point, the project can be approved. Now I'll fill you in on the final processing steps for the notice of determination filing phase. Within 5 days of project approval, DTSC is required by CEQA to file a notice of determination with the State Clearinghouse. You'll find an NOD processing guidance and CEQA Informational Bulletin number 5 on our SharePoint site. It's best that the notice of determination package be compiled well in advance of the project approval to ensure that the 5-day filing deadline is met. The notice of determination filing with the State Clearinghouse starts the 30-day legal challenge period on a negative declaration. Otherwise, the challenge period extends to 180 days if the notice of determination is not filed. Note that CEQA challenges go directly to court, and no further administrative options are available at that point. Also note that for permitting projects, the notice of determination is filed after the permit appeal process is completed. Okay, now the final sections of our presentation pertain to OPIA CEQA technical assistance. And as a project manager, we realize that you have many things to remember, and our staff is available to assist you at any stage of the process. Please use the EnviroStore general work request to obtain consultation from our office and direct your request to Kathy Schievelbein, Chief, Office of Planning and Environmental Analysis, Office of Legal Affairs. And after the OPIA org chart on the next slide, I'll show you a view of our SharePoint page and some helpful items that you'll find there. Okay, well, here's a view of our structure. Our office is managed by Kathy Schievelbein, Chief and Supervising Environmental Planner. Candace Hill, Gunther Moscat, Kim Hudson, and I are Senior Environmental Planners with lead roles. Candace oversees the day-to-day review and approval of CEQA documents prepared by program staff. Kim provides oversight and technical expertise on environmental impact reports. Gunther is a retired annuitant for CEQA consultation and training, and I'm lead for training development. Carolyn, Nancy, and John are associate environmental planners and are responsible for reviewing CEQA documents submitted by program staff. And Nikki Barnes is our training technical assistant.
We do have a question. Don't all EnviroStore requests to OPEA automatically go to Kathy?
Yes. Yes, correct.
Yeah.
Okay, and a couple more.
All right.
Does the 30-day legal challenge period mean we have to wait another 30 days after the project is approved by DTSC to be able to start work?
No.
I don't know if that came through. The answer
No.
to that question is no.
No, once the NOD has been filed, the project can go ahead and be implemented, unless there's a court injunction that stops the project.
Okay. And then another question, where can we see the PowerPoint presentation for both presentations?
Oh, the PowerPoint. Yeah, you should have received a link to those documents when you signed up. But if not, the presentation itself will be posted at a later date to our SharePoint site. It is being recorded today.
Okay. And one other question, who pays for all of this support? This is not a trivial question. Project managers need to plan for the cost. What are the typical costs for the level of effort in the process that you are discussing?
Well, I don't know the specific costs. We charge, there's one planner assigned to a project. That planner charges directly. That cost is comes from the program or from the facility or the responsible party. And so, Marilee, I don't know if you want to get involved or Gunther.
Yeah, the costs are anticipated in the permit application process. In terms of how much time you believe, for example, a permit project manager might feel it takes to do the technical portion of it. It's an estimate of CEQA hours. And as you know, that's built into the upfront cost of the permit. And then in the cleanup program, it's cost reimbursable. So whatever charges are incurred, on the cleanup portion, as well as CEQA sites, are counted in the data logging, and that's paid for by the RP.
Okay, we do have one more question. For the Navy and Air Force projects, we cannot charge to CEQA.
That is technically correct. However, it's been practiced over the years that the folks that are in the military program would have an indirect way of charging that cost. I'm not positive if that's changed at this point. There are more willing, if you will, military branches such as the Navy, who may be more inclined to do that as opposed to other branches. But the internal way of how that is charged is really something that the military program is aware of and is somehow implementing. We don't have much oversight in that regard. I should say no oversight on that.
Okay, do we have any other questions, John?
I think there's some, there's some crosstalk. And let's see if I can find a most correct question. Please ask the presenter to confirm that slide 14 notes that the CEQA analyses are required only for work done by DTSC and DTSC contractors, not for cleanup program work undertaken by PRPs.
I'm not sure I understand the question.
Yeah, maybe for the person asking that question, maybe you could send us an email with a little more detail so we would know how to respond. We're all looking at each other right now, kind of wondering how to. So a little more information would be helpful.
Okay, I'll send an email.
Thank you.
Okay. All right. So, okay, so here's a view of our SharePoint site. You'll find us under the Shared Services tab, and we've got a great deal of OPIA and CEQA-related information there. And on the left bar, you'll see that we have our mission statement, upcoming training announcements, public notices of CEQA documents, CEQA informational bulletins, policies and procedures, the DTSC initial study workbook that walks you through the initial study process, training modules such as the Bay Area Air Quality Management District information, CEQA implementation within DTSC, and guidance for use of the Class 30 categorical and general rule exemptions for small cleanup projects, along with sample documents. And on this slide, you can see some of the topics included in our informational bulletins. These bulletins provide some practical information and can often answer many of your questions about the CEQA process and how it's handled within DTSC. And now we're going to attempt to open up a bulletin for you, so please bear with us while we do a little technical switch over here.
And while we do that, let me present one of the questions that we have outstanding. Given that all field work appears to require consultation with OPEA, do you have sufficient staff for the additional consultation requests that you are likely to receive?
Well, that's a good question. I don't know how to answer it because I don't know what we're going to be receiving. But as Laura had pointed out earlier, we have had in place an internal policy of 15 days for review. We would appreciate your taking that into consideration because we are limited on staffing resources. And so just keep that in mind when you submit a request. If you can allow a couple of days in there, so if it's just for a couple hours of consultation, that would be very helpful.
And related question, what are the estimated hours for an NOE and the initial study process? Estimate for OPEA staff.
Well, we have a workload standard in place, which is generally 40 hours for an initial study. That, however, contemplates a pretty perfect document coming in. So keep in mind that given all of the resources available on our SharePoint, consultation services for one-on-one consultation with us available to you, it could be the case that it would take longer than that. And those of you out there who are chiming into this training have probably had an experience or two going back and forth. We want to try and avoid that to the extent possible. We do our best to triage projects coming in so that we identify right up front and get back to the project manager those areas there that would need some improvement on your initial study, areas where we can help you getting some data for you and so on. But that has to be factored into that workload standard. That is just a standard.
One more question. For clarification, do we need to do a CEQA analysis if we are reviewing a work plan for an NPL site or a site being investigated by a responsible party, not us?
Well, the NPL site, yes, but I'm not sure on the angle of the question was the responsible party.
Okay.
So I need some clarification on that one.
If they could send an email on that.
Just a detailed background of where you're going with the question would be helpful. Thank you.
Okay, so I brought up our CEQA informational bulletin number 8 that's about guidance reads of the Class 30 categorical and general rule exemptions for site cleanup projects. Again, you can see the general format of our informational bulletins. We state who the target audience is. We provide a little bit of background, and also then we get into the actual nuts and bolts of the topic that's involved. So just to give you an idea of what those look like. And as you can see, we have 10 topics at the present time. We're always in the process of considering new guidance that might be needed. So although there are 10 today, there could be more later on. So check back periodically from time to time. I also wanted to point out that on the right side of our page, you'll find some information resources there. As I mentioned, we have the public notices of CEQA documents, an air district map, so you can get the air district contact information for your project and have some dialogue with the local air district to get some information on greenhouse gas or air emissions rules that may apply to your project, the water boards, fish and wildlife offices by region, those contacts, and various others. Okay, bear with me for a moment while we have a final slide here that is like the one that Seth presented earlier. In fact, it's the same slide. That concludes our presentation today. I'd like to take any additional questions that folks have. We have a few more minutes left. Thank you for attending today. We value your input, so please do complete the evaluation that will be sent to you electronically after the presentation today. And
we have a question. Is there a policy stating that a CEQA review and potentially a CEQA evaluation, an NOE, notice of determination, etc., would be needed to be completed for all work plans that are reviewed by DTSC?
It is contained in existing DTSC policies and procedures. That goes back probably to 1990s or so. If you go to the SharePoint site and browse through the policies and procedures, you'll see that there have been more than a couple of policy directives, stating the intent of CEQA implementation within DTSC and what types of documents would be subject to CEQA review.
So there was a kind of a related question that the cleanup programs review dozens of field work plans every month, work being done by a responsible party, not DTSC. And slide 14 states that only work being done directly by DTSC has to undergo a CEQA evaluation, not work done by responsible parties.
Let's see if I can interpret that a little bit. The CEQA would apply in two situations. If DTSC itself is carrying out a project, like orphan sites, or if, for example, Caltrans is going to build a bridge, they're a lead agency, so they're carrying out that project. Or if the work is being done by a private individual or corporation, in this case RPs, who have contractors, where they require our approval of the associated work plan and remediation effort.
Okay. One other comment or question. Could you send an email to all cleanup program project managers when OPEA updates their forms or guidance so that we know when this is done?
We certainly can. Two things. You certainly want to visit our site often. We have new things that are made available. Whenever we post informational bulletin, we send it out to supervisors, correct?
That we will double check.
Okay.
Yeah.
And if we haven't been doing that, we will do so.
Okay, and we have two questions that occurred a little earlier and we didn't get to. One is a question about what if an NOE was issued for a permit 10 years ago and the permit renewal is coming up? What should be done?
You ought to consult the Office of Legal Counsel because every situation is very fact-specific.
Okay. And
the Office of OPEA as well. We can have a meeting together about it.
okay. And one that may take a little while to discuss is, should we put all permit renewals on hold until the forthcoming policy is implemented and the PMs are trained?
No. You know, you need to go through the process that has been in place, submit an EnviroStore request. Marilee laid out for everyone that we needed to do an environmental assessment of the document that was done for the previous issuance of the permit. And so we can talk about going through that process. She also laid out that it's very similar in terms of the questions or the prompted questions in an initial study that you could use as guide to ask those questions of that previous document and gather information about the surrounding community and the site, about the facility, what they're proposing now. There's a lot of information that everyone who works in permitting knows needs to be included to contact our office so we have sufficient information to be able to address how to move forward.
And this is Marilee, just to reinforce what Kathy's saying. No, there's no reason to put any permit renewal on hold. You should go forward with your work of figuring out exactly what it is they are asking for in their new permit and comparing that to what they are currently authorized to do in their current permit, which is something you'd be doing anyway. And then we're going to go forward and figure out exactly what type of environmental document is the appropriate one to do. It's really not that much different than what's been going on already.
Okay. One final question, or one more question has come in. If a city is proposing a redevelopment project at a site and the cleanup is just one piece of this, is DTSC's responsible agency checklist process focused on only the cleanup project and the cleanup project's potential impacts?
Yes. The way that CEQA operates is the agencies such as ours that are responsible agencies, we have to limit our comments to our area of statutory responsibility, and that would also include, suggestions for mitigations if we see impacts that we feel would relate to our project. And keep in mind that the analysis that we conduct as a department in the role of the responsible agency isn't just limited to the hazardous material sections. So when you see an environmental impact report or a mitigated neg deck or neg deck, and you're reviewing the assessment, look at the other areas that would potentially relate to your project, such as air quality impacts or transportation or geology or water, whatever the resource area you think your project might impact, and then provide suggestions for the agency to include an analysis of those impacts in their lead agency document.
Okay. Do we have any other questions, John?
No, we don't.